All right. So starting 2009, July, question one. And this was a little bit unique. And believe it or not, this was the one essay that I was privy to a calibration session, so I knew everything that was about. And when I had my original score sheet for this one, I had this one listed at 59% as my guess, and this one at 41%. And according to the calibration session, it was actually 60-40. I'm like, okay, I'm doing good. And they even asked all the professors in there, do you think it's fair that we test malicious prosecution? How often do you go over it in your class? So this was actually what happened at the calibration session for this particular essay. Okay, Dave filed suit against Pat and Art for malicious prosecution. So Dave was obviously a defendant, I think. Patty probably a plaintiff, and Art an attorney. And there's a difference why Art and Patty have to be separated. There's different standards for attorneys versus regular people. I mean, how many times do you have a friend come up to you and go, hey, can I sue somebody for this? They walked across my lawn. Do I get $1 million? No, it doesn't work like that. As an attorney, you're supposed to know better. As general plaintiff, they're not a general person, a regular person. They're not going to understand things the way that you are supposed to understand things. So there's going to be different standards, and you will separate them. Number one, did the court correctly grant Dave's motion to dismiss on the ground stated? So obviously, somewhere in the fact patterns, Dave was sued and he dismissed the case because there was no legal basis for it. That's what a motion to dismiss is. It is a procedural device that you'll learn in civil procedure that allows you to dismiss a case when there is no factual basis for your legal claim, and you can't win as a matter of law. Number two, what's the likely outcome of Dave's suit for malicious prosecution against Patty and Art? Which means they brought a claim against him. He obviously won because in call one, his claim was dismissed. He won the motion to dismiss, and now he's suing them for bringing frivolous charges. That's what's going on, just based on the call of the question. From the top, Patty is in the business of transporting human organs for transplant in city. And for those of you that are organ donors, just so you know, they will take your organs before you die because they're more viable and they can make more money. You're better off. You're more valuable to the hospital dead than you are alive. So keep that in mind next time you think about becoming an organ donor. She is paid only upon timely delivery of a viable organ. Delay of an hour can make an organ non-viable, which is why they're not going to wait for you to die. So keep that in mind. And if you don't believe me, go ahead and check that out. Google that. You'll be surprised when you hear some things. Dave transports gasoline over long distances in a tank truck. Okay. Recently, he was hauling gasoline through city. Dave was crossing a bridge in city. His truck skidded on an oily patch and became wedged across the roadway, blocking all traffic in both directions for 2 hours. Okay, so his truck skidded on an oily patch and became wedged. So whether or not he was negligent, exercising reasonable care, who knows? It could have just been a freak accident. But it looks like he blocked traffic, and traffic was backed up for 2 hours. Patty was delivering a kidney and was on the bridge several cars behind David when the accident occurred. Traffic jam caused Patty to be 2 hours late in making her delivery and made the kidney non-viable. Consequently, she was not paid the $1,000 fee she would not have otherwise received. So let's just take something as a given. Let's just say Dave owes a duty of care to other drivers on the road. We all agree with that. It's easy. Dave, assuming, let's say he was negligent in driving, he breached that duty of care. And did it cause her, was it the actual cause of why she didn't deliver the kidneys? Yes. Is it foreseeable that if you block traffic in both directions, people are going to be late to their appointments and whatever the case is? Yes. Does she suffer any damages? For negligence and strict products liability, you need to show personal injury and property damage, not economic loss. So if this happens to you on the way to the bar exam, you can't sue the driver, no matter how careless they were, because you didn't get to the bar exam in time and you lost 6 months worth of salary, even if you can unequivocally prove it, that you would have passed and a job was waiting for you. Economic loss is not recoverable. Now, a little side note of something that I saw tested twice recently on the MBE with products liability, which might actually surprise you, something that, believe it or not, I didn't know until a couple of years ago. If I was to buy a truck, let's say I bought a truck at the dealership, and something's wrong with the truck, it's default, it's designed default, it's a faulty design, and the truck ends up blowing up. Now, let's say the truck was parked on the street, It did absolutely no damage to any of my personal property, and it did no damage to myself. The only damage was done to the actual truck. Believe it or not, you can't sue for products liability. You can only sue under a warranty theory, for breach of contract, for breach of warranty, implied warranty of the implied warranty of merchantability, and that's it. And your damages are limited to the value of the truck. So essentially, they just give you your money back. They take the truck, but you can't sue under products liability. A concept that I've seen tested recently a few times on the MBE, which kind of would blow your mind. Wait, you can't bring a products liability because there's no damage to you personally and to your property other than the product itself. So we'll get into that a little bit more later, but just so you understand that concept as it relates to this, here we only have pure economic loss. So let's say, taking everything Patty says is true. Let's say that she sues him for negligence or even strict liability. Everything she says is true. Can she prevail? No, because she didn't suffer personal injury or property damage. So as a matter of law, she can't win. That is why that probably got granted. Okay. Patty contacted Art, a lawyer, and told him that she wanted to sue David for the loss of her fee. And rightfully so. She doesn't know any better. She thinks that she has a case. And all right, I mean, how would she know this? You guys went to school for years, take the exam so that you can learn this. And some people still don't know even after they pass the bar. So as a lawyer, you're supposed to give the advice like, hey, I can't take this case. You actually don't have a claim. And here's why. But here's what happened. There isn't a lot of money involved, but I want to teach Dave a lesson. Can you bring suit if you have a viable suit, even for a small amount? Let's say I don't like one of my neighbors. My neighbor keeps walking over my lawn, and I want to bring a suit because I don't like my neighbor. Can I bring that suit, or is that malicious? Well, believe it or not, I can bring that suit. And even though I have hatred towards the person I'm suing, I actually have a viable claim. And that's what the courts are there for, the type of redress that people are looking for. So even though she wants to teach him a lesson, if she really did have a claim, it doesn't matter the motive for why she's bringing it. Most people bring lawsuits because they're tired of dealing with the other party. They can't settle. They're not going to be able to recover any money. They're not going to be able to get the resolution they want. Dave can't possibly afford the legal fees to defend his case. Most people can't. Most lawyers can't. So maybe we can put him out of business. All right. I mean, that'd be an ancillary benefit if you actually had a claim. Art agreed and concluded that he could not prove negligence against David. Okay, because you can't show that he breached the duty of care. But decided that the only plausible claim would be based on strict liability for ultra-hazardous activity. So you'll hear the words ultra-hazardous or abnormally dangerous. And here's the difference. Ultra-hazardous was used in the restatements first and second. They now call it abnormally dangerous. It doesn't matter what you call it. And the restatement second used to have elements. Now they're just considered factors. So what's the difference? Elements need to be proven. Factors are things you consider. So now everything's just taken into consideration, meaning it used to be if it was common in the community, then you would be completely barred. Now it's just a factor to consider. And even though it is common, you can still bring a abnormally dangerous activity lawsuit. So what, like, and you're not, instead of trying to memorize all the elements for what is it, I just like, okay, well, is it something that's common? Can it be made safe? So common in the area. Can it be made safer with the exercise of reasonable care? There's certain things like pesticides. How do you make them any safer? The whole point of a pesticide or toxic chemicals or, somebody working on a lab in Wuhan, there's a reason why certain things are just abnormally dangerous. And it wasn't a bad one. Although South Park pretty much convinced me that it was. Okay, common in the area, safe with the exercise of reasonable care. Also, let's see, the utility of the product. Like, okay, if one of the biggest factors is how useful is this? How useful is gasoline? How useful is electricity? I mean, those are very dangerous things, but there's ways to make it a little bit safer for electricity, like put up fences or guardrails. These are all common things that are in the area. But pesticides aren't usually common in like a city. And the utility of the product, well, we can't have a hard time functioning in a society without gasoline. Except if you drive one of those Priuses. And so those are just factors to consider when you're talking about a claim for products liability or ultra-hazardous activities. Art filed a suit based on the theory against David on behalf of Patty, seeking recovery of damages to cover the fee she lost. So even if it is abnormally dangerous, so that with products liability and abnormally dangerous activities, once these things are proved, all you show really is just kind of, it's a breach of duty, what it is. So it just shows that you have a strict duty and that you breach that. That's what products liability is. But there's still causation and damages. So it's very similar to res ipsa loquitur in a way, because res ipsa loquitur and even negligence per se both cover breach of duty. If I violate a statute, I breached my duty, you still have to show causation and damages. Remember, we did the lifeboat thing. There wasn't enough lifeboats. And so by not having enough lifeboats, you breached you breached the statute, you breached the duty. But the fact that I died had nothing to do with the number of lifeboats, because even if there weren't enough lifeboats, I still would have died. Same thing with the rearview mirror. If I don't look in my rearview mirror, I've committed a breach of the statute, so I breached my duty. But even if I looked in my rearview mirror, I still want to see the kid ducking behind my car because he was so low down. So there was no causation there. That's how actual cause works. So you still need in every product's liability, strict liability, or negligence case, you need also causation and damages. Well, causation here is pretty easy because, but for him getting stuck on the freeway, she wouldn't have been late, and it's foreseeable that that would happen. Now, the damages part, again, we still need personal injury or property damage, which we don't have. So the fact that we only have pure economic loss means, as a matter of law, you cannot win. Does that make sense? So assuming that, taking all the considerations in there, that this is an abnormally dangerous activity, right? Let's concede that. And that it caused her to not be able to deliver the kidneys. But no matter what, she still can't prove, based on the facts of her complaint. That's why you dismiss it. Because I'm going to read this complaint as the defense counsel. All right, taking everything you say is true, you still can't win. And that's why you dismiss as a matter of law. And when we get into Civ Pro next week, you're going to notice a motion to dismiss, a motion for judgment on the pleadings, summary judgment, directed verdict, and renewed motion for directed verdict. It's the same motion at 5 different places in litigation. So you have, and this is why litigation goes on for so long in civil cases, which takes years, because I'm going to be making that motion every single stage. Charge my client more money. That's the whole point of this. So there we go. And Art, as a lawyer, should know Patty doesn't have a claim and should never bring this claim. So Patty doesn't know any better. So in a suit for malicious prosecution, she thinks she has a viable claim. She really does. Most people would. But as a lawyer, he should know better. And therefore, the malicious prosecution case against her she'll probably win. But against Art, Dave will probably win. Okay. Cannot prove no. Okay. The facts recited in the first 3 paragraphs above appeared on the face of the complaint. So, taking everything you say is true on the complaint, you still have not asserted a legal cause of action that could give you any remedy. And that's the whole point with the motion to dismiss, is wait a second. All right, we'll concede everything you said is true. You can't win because you haven't shown personal injury or property damage. So what happens in a situation like that? The court will give you leave to amend, and hopefully you can come up with but she's not going to be able to come up with it, so dismissal is proper. So Dave filed a motion to dismiss. The court granted the motion on the grounds that the complaint failed the state of cause of action. Does everybody understand what that says? It failed the state of cause of action. Because does she have a legitimate claim for abnormally dangerous activities? No, you clearly do not. You cannot make out a prima facie case. So she can't make out a prima facie case for negligence, ultra hazardous activities, or anything. So, and the damages alleged were not recoverable. I can't believe the examiners actually go out of their way and give you the answer. That's just crazy to me. They say the court granted the motion on the ground the complaint failed the state of cause of action. That's all they should have wrote. But no, they're going to spoon feed it to you. They're going to say, and that in any event, the damages alleged were not recoverable. Oh, I guess what they're saying is it's not abnormally dangerous. And even if it is, you didn't allege any damage. So they're saying there's 2 different parts. I get what they're saying. But still, they kind of give the damages thing away. Dave then filed suit against Patty and Art for malicious prosecution. And malicious prosecution, which applies to civil case, also they call it, there's another similar cause of action called abusive process. That's like when you use the legal system, the process for getting a restraining order. or attaching someone's, like seizing someone's assets, or filing an action to like seize their property, that's abusing the process for malicious purposes. So what's malicious prosecution? That means, well, Dave must have won the pursuit, which is clearly obvious because he did. There has to be, what are some of the things for malicious prosecution? An improper purpose. So what an improper purpose means is that you're bringing it for the wrong reasons. Now, it might seem that Patty is bringing it for the wrong reasons, but it's ancillary to the point she's actually bringing it to recover her fee. So she's bringing it for a good reason. So I don't think there's an improper purpose for bringing it. The other thing is, like, did you have probable cause, or did you have sufficient facts? Well, she thinks she does. And that's why you separate the difference between Patty and Art. She honestly believes she's got a legitimate claim. You can't deny that. But Art should know better. So Art knows there's no probable cause. Patty thinks there is. And so that's why. And lay people are entitled to rely on counsel's advice because they're generally going to follow it. And Rule 11 is something in Civ Pro that if you bring a frivolous claim, so what happens? So let me explain Rule 11 because it gets incredibly heavily tested in Civ Pro. So what happens is, if I was Dave's attorney, I would say to Art, I'd say, hey, look, you don't have a cause of action. You have an alleged personal injury or property damage. So you either withdraw it, or I'm going to serve you with this motion for sanctions in 21 days. And I send them the motion for sanctions that I put together. And if Art doesn't dismiss this case within 21 days, then I'm going to file my motion for sanctions. That's Rule 11. Rule 11 will sanction the attorney, but because she's represented by the attorney and it's based on an improper legal theory, she's protected because she's entitled to rely on his advice. That's what Rule 11 is. Very heavily tested on the MBEs. Always one question on it. I don't know what the other, and of course you have damages or whatever the case is because he had to defend, he had to file the motions, everything like that. I don't remember what all the elements are, and that's okay if you don't remember. I'm just thinking off the top of my head. Well, what happened? Like, they're kind of giving the improper purpose. I understand that one person thinks there's a claim, one knows there's not or should know. Of course, he won in the first suit, and there you go. That's a wrap up of this. What they were really getting at again was the property damage. I'm sorry, the personal injury property damages thing, and the different types of factors for gasoline. I wouldn't find gasoline to be abnormally dangerous, but even if it was, you still can't win. And then Dave will probably win on his malicious prosecution suit against Art, but not Patty. All right. So there's a recap of 2009 July question 1.